If there wasn't a six-figure verdict in Sandusky County until a $500,000 verdict a couple years ago, and we just got another six-figure verdict just about a month ago. So there's only 2 six-figure verdicts in that county's history, and it just happened within the past couple of years.
That's Kyle Wright, partner at Wisehart Wright Trial Lawyers, and the attorney behind the first 2 six-figure verdicts in Sandusky County history. He self-funded his Make It Right brand even before his firm officially backed the idea. He proved that visibility builds a strong trial reputation, and a strong reputation drives referrals.
I budget $15,000 for CLEs for each attorney. In my practice, I budget $35,000 annually for myself for training. So we just build that into our budget.
In this episode, you'll learn why self-funding your personal brand can build a referral pipeline before your firm is ready to invest, how a $35,000 annual training budget can help create the trial record that drives attorney referrals, and why using personal income to fund visibility can reduce partner conflict and keep the strategy moving. I'm Jason Lazarus, and this is Trial Lawyer View. You built your trial practice in Sandusky, Ohio, not Cleveland or Columbus. What did the smaller market choice force you to figure out about case selection, marketing, and reputation that perhaps firms in a big city might never have to wrestle with?
I'm fortunate, frankly, that I started this in a smaller county. So I'm in Erie County, and we're halfway between Toledo and Cleveland, right on Lake Erie. My main office is in Sandusky, and the competitors or the competition here for injury cases it's much smaller. It's than you would encounter in Cuyahoga County or Lucas County. So I think, to start, it's easier to gain a foothold and grab a market share in a smaller area. And then, if you fill your cup here, then you can, you've got the capital to double down and try to reproduce in different markets. So that's kind of where we are right now.
Well, and interestingly, you've had this concentration in trucking, and most personal injury firms out there seem to chase volume across different case types, but you went deep there. Can you kind of walk through with me how you made that decision and what you had to give up to go that route?
Really, I made the decision to spend some time, a lot of time, and invest a lot of time in learning as much as I could about the FMCSA or the Federal Motor Carrier Safety Regulations. I went to every seminar I could go to on trucking. I joined the trucking groups. I read all the books. I initially co-counseled with some trucking lawyers that I really respected. I went to Montana and got behind, the wheel on semi trucks, and boy, that was kind of a shocker. I got there in Montana, and within the first 2 hours I was there at the seminar I was at, I got in the front seat of the semi truck, a brand new tractor trailer, and the coach handed me the keys, and she said, "Are you ready to go?" I said, "Go where?" She's like, "We're going out on the track." I said, "Well, look, I've never driven stick before. I don't know if my first time to do this is probably right in a semi truck, but I did." And so it was a lot of fun. Learned a lot. Really learned a lot from that experience.
Hi, quick question for you. Does lien resolution administration feel like a quiet bottleneck inside your firm? Medical liens, Medicare compliance follow-ups, and documentation can drag on long after the case is resolved, tying up capital and attention your team could be using elsewhere. This is where Synergy can help. We partner with personal injury law firms to handle complex healthcare lien resolution and compliance work. helping firms move cases to resolution more efficiently without adding internal burden or more overhead. If that sounds like something your firm is dealing with, you can learn more by clicking the link in the show notes or scanning the QR code on the screen. Now back to the conversation. I'm a little bit of an amateur race car driver, and I instruct others on track when they're coming out for the first time. And so I've been in the right seat and been out there with people that are just learning. And really, I mean, the best way to learn it, honestly, is to go out and do it. It's hard really to understand till you actually do it and feel the forces that are produced when you're driving at a high performance level. And I'm curious, with what you did in Montana, what specifically did you learn about trucking cases that perhaps those that don't specialize in that area miss when they take on a case?
Yeah, so we learned a lot. I mean, it was over 3 or 4 days. We learned about how to properly secure load. We learned about, all the pre-check that you are required to do, and just learn the mechanics of a tractor trailer, how it operates, how different it is than just a motor vehicle, a regular car on the road. And, it gave me some really good insight into how important it is to really follow the safety rules, to make sure that we're, truck drivers are safe and hauling loads safely across America. So it's a big responsibility for the truck driver, and it's even bigger responsibility for the trucking company to give their drivers the tools that they need to be successful and to be safe, and for the trucking company to put training in place to help these drivers. It's important to just do ongoing training, just like it is for us as lawyers. Just the ongoing CLEs that we do, how important it is. They've got an important job, and it's critical to do things the right way.
Yeah, I got to imagine, for those that are driving these rigs, and I only talk from my own experience of trailering my own car, because when I go to the track, I trailer it. And what I see oftentimes is on the roads, the drivers don't quite understand how much harder it is to stop a vehicle that's longer and more weight and don't give enough room and, all those things. But then also, they're as an operator of a vehicle like that, you start to get a feel for, this is something, different than when you're just driving around in a passenger vehicle. I'm curious in terms of the training that you're talking about, how much of it actually occurs that helps to avoid the types of catastrophic outcomes that can happen when somebody's behind the wheel that doesn't have that proper training and expertise on operating a vehicle like that.
Yeah. I mean, I think it just starts with culture of safety with the trucking company. Every business has its own personality. It starts from the top. And, if there's a culture of safety and training, that's going to make its way down to the drivers. They're going to understand what their priority is, and their priority is to safely transport their load wherever it's going. And it starts with the company. And, the good trucking companies really care about safety. They care about the safety of their driver. They care about the safety of others on the road, and they care about the load that they're hauling. So I think it starts at the top, and I think it's a culture thing. And so, I think the really good companies take a lot of pride in that, and they do a lot of training, and, just enforce that culture on their drivers.
For you, what is it about those types of cases that calls you to hold those companies accountable when they don't do the things that you just talked about and hurt someone that you end up representing?
So here's the way I look at it is, if there's a collision with a tractor trailer and a regular car on the road, Just the basic physics of that size of a vehicle versus a smaller vehicle, the tractor trailer is going to win, right? And so it doesn't take the same amount of speed, right, to cause the kind of injuries that, may happen with a higher speed or a lower speed collision with just a regular car. So I've seen and been involved in many cases where there's just catastrophic outcomes to people that are hurt, in a tractor trailer collision, and the goal is that to prevent those crashes, right? So every crash is preventable in some way. It's we ultimately it's the job of the trucking company and the truck driver to prevent crashes. And I've been involved in so many different catastrophic cases that are just clearly preventable if there was a culture and a directive from above to follow the safety rules that are in place to prevent these kind of crashes, because the outcomes are catastrophic generally in comparison to a normal car v car crash. So I am moved to help those people that are negligently hurt. I live with the families. I see the pain that they're going through, and I spend a lot of time with them, and I see what's going on. And when you see that over and over and over, it's just that there's kind of a calling there to help people, and that's what I do. I really enjoy it.
And I've seen some of the most catastrophic outcomes in those cases, and it's really heartbreaking when you know that there was something that could have been done to avoid it and simply wasn't done, usually because profits were put ahead of the safety of those around those types of vehicles, which that's where you guys come in and hold them accountable.
What we end up seeing a lot is some of a lot of the companies, they have different telematics and safety alerts that they're made aware of when their truck driver is speeding, or their electronic logs, whatever it is. The companies put on notice, and the question is, what did they do with that information, right? So you can have all these, you can have all the bells and whistles in place, but what are you doing with that information to correct the driving, to order additional training, to coach and work with the driver so that you can prevent a crash? So that's what I see a lot is there's all this safety in place, but they're just not training and using that information to make their drivers better. That's what I see a lot.
Yeah, it's an unfortunate reality. So you have two of the top verdicts in Sandusky, and I'm curious, what does that statistic say about how you prepare for trial and how you decide which cases belong in front of a jury?
So it's in Sandusky County. It's a smaller county here in northern Ohio. And, it's been historically a very difficult county to try cases. It's not been favorable to plaintiffs. There wasn't a 6-figure verdict in Sandusky County until we had a $500,000 verdict a couple of years ago. And we just got another 6-figure verdict just about a month ago. So there's only 2 6-figure verdicts in that county's history, and it just happened within the past couple of years. One of the benefits, I would say, of trying cases in some of these smaller rural counties is that the judges are surprised when the plaintiff's attorney is willing to go to trial. And they're kind of excited to see it actually happen, because people are afraid to take a swing there. And, it allows me to kind of cut my teeth and get trials in. I think sometimes it's harder to get trials in the bigger counties. You get kicked over and over. There's a huge docket. But in the smaller counties, you get, I think, more of an opportunity to try cases, which I'm grateful for.
You have achieved a $5.7 million pre-suit policy limit settlement, which is unusual. I'm curious, when I saw that, about what made the carrier come to the table that early without you needing to file.
It was a catastrophic case. I mean, it was a head-on collision where a minor was paralyzed. And so if there ever was a case for that carrier to pay their limits, that was the one, right? So I give the carrier credit in that case for doing the right thing and getting it resolved early for this child, because he needed the care that that settlement's been able to provide him.
Yeah, but it's still unusual to see that, because over my career, I can't tell you how many times I've seen those types of cases where they've been drawn out much longer than they should have.
Yeah. It was a matter of, frankly, getting all the expert reports, getting everything lined up so that, they knew that if the money wasn't paid, that we were ready to go in litigation. I mean, we had a life care plan. We had a day in the life video done. We were ready to go. So that message was, I think, received loud and clear. And that got the attention of the carrier. And ultimately, when they paneled it, they made the right choice to get that thing done.
So you did all of that in basically as you onboarded that case, meaning because it was pre-suit. So you were doing all of that very early on.
Very early on. I mean, we found out that there was video on one of the neighboring buildings on the roadway. So we got the video, and it was clear that the driver went left of center. So, we eliminated any liability arguments just by way of having the video preserved and sharing that with the adjuster early on. And then we ran, and once we had that, we got all the expert reports that we needed. We had an excellent life care planner that spent a lot of time with my client at their home, getting an understanding of the injuries, clearly laying out a life care plan that he'll need. And then we had the day in the life. So it was ready to go early on.
Great result. And obviously, that's a situation where that money, because it's tendered early, can make a difference in terms of how that person gets to live and what type of recovery they have and what resources they have. And having worked with disabled clients my entire career, that is such a huge thing for that client not to have had to wait years and years for that money to finally be paid.
Absolutely. No, it was huge. I'm very happy for the clients, under the circumstances, awful situation for that family. But, we, with the settlement, we were able to really deliver the best kind of quality of life and provide him with the resources and tools that he needs to maximize the quality of life that he was left with. That's huge to me.
So specialization is as much a business decision as a craft decision. I'm curious about your filter on which cases to take and which to pass on has changed over the years, and what mistakes you made early on in your practice.
I would say earlier in my career, I was more willing to take risk on lower value cases. That starts to change as your practice grows. I went through that just natural growth curve. I worked cases hard no matter the size of the case early on, and it's ultimately worked out. And some of the cases, I've developed a practice now where I just basically am working on the catastrophic cases. So I have a much smaller caseload that I split with just a phenomenal associate that works the cases hard in litigation, that truly wants to be a litigator, that handles high-end discovery, that does research and writing and takes depositions. And we work cases up differently now. Especially the catastrophic cases, we're able to just throw a bunch of resources at it that I wasn't able to necessarily do earlier in my career, and we can move them along quicker too. So Yeah, it's kind of a blessing in that regard.
Well, it's a good segue into what I was going to ask you about next, which is most personal injury firms, or many, avoid the courtroom, and your firm doesn't do that. And I'm curious, from your perspective, how do the carriers, knowing that you guys will try a case and getting it prepped early on, like you did in the case that we were just discussing, where you got a policy limit pre-suit demand, how does that change what they offer you on files? And was building that reputation a deliberate choice on your part?
Yeah, it was a deliberate choice. I mean, it was just a total philosophy change. I mean, I started with focusing on how to resolve a case pre-suit and by way of settlement to maximize a case, and really understanding that. And, ultimately, look, if you're a personal injury lawyer and you're not trying cases, you're not getting the full value. And that didn't sit with me right. So I refocused my practice on trial. And, I honestly just put myself in as many uncomfortable positions as I could, practicing in front of groups, attending seminars where I'm on my feet. I'm doing this work, I'm prepping it, and I'm doing focus groups. I'm practicing an opening, I'm practicing cross-examinations, doing it live, getting feedback, reading all the books, studying the best of the best, frankly, on CVN. I mean, that's an incredible resource for any trial lawyer. You can, at any time, if you pay, $1,000 a year to CVN, you can go log into CVN and watch the best of the best. How do they craft their opening? How do they cross-examine expert witnesses? How do they do the direct of the client, the damages witnesses? How are they framing damages and closing? So I just spent a ton of time just researching that, everything I possibly I could do, and I love it. It's not work to me. It really isn't, because I enjoy it. Every day I get up, I'm happy to get to the office. I don't feel like I'm working. When I'm home or working out or walking on the treadmill, I can throw CVN on. I can watch an opening statement, catch whatever I want to catch. And, I'm always trying to study what the best of the best out there is doing and pulling what works for me and applying it to my own cases.
Well, another good segue, because from doing my research, my understanding is that you invest in trial training for the lawyers at the firm, and that's something that's a little less usual because the reality is a lot of cases settle and don't go to trial. I'm curious, what's your business case for that investment, and what does it actually look like for you in terms of the lawyers in your practice?
So I have, I budget $15,000 for CLEs for each attorney. In my practice, I budget $35,000 annually for myself for training. So we just build that into our budget. I tell all of them that they're required to pick 2 of the best training seminars wherever it is in the nation. It doesn't matter to me. 2 of our associates just went to California to do the Trial by Human seminar. Not cheap to fly to Hollywood and stay at a hotel and pay for flights and do the advanced training, but the return on investment is huge, right? Because I want to work with people or lawyers that are interested in what I'm interested in. And what good does it do if I'm the one that has all the knowledge and the resources because I'm, investing in myself? What does it do if I have all that knowledge? I'm not working all the cases, right? They need to get up to speed and get that same knowledge so they can apply it on their cases and get the best values that they can. Historically, I think firms would take the position that, look, we're going to retain all the information and the resources at the top so we can, maintain control, right? So that I think there's a fear that people might leave if they learn, the tricks of the trade. But that hasn't played out in my practice. They're grateful for these opportunities. I looked at it differently, and so far it's working.
Well, and I would imagine you upskilling and everyone around you upskilling is a very positive thing for the firm as a practice, because that just means client experience or client results are improved, and that's really in the end what's going to continue to drive more and more work for you guys is that.
For sure. No, it's a huge part of my practice, I would say. So right now, almost close to 50% of the cases that I generate are attorney referrals. So it's just over 40%. If you are able to get high value on significant cases, then attorneys are going to refer their cases to you. That's really where we've gone. That wasn't necessarily my intent as far as like how I wanted to grow my practice, but that's what's happened.
I wanted to ask you a little bit about your personal brand, because you've got Make It Right, which is very clean. It's recognizable. I'm curious about what led you to build that personal branding and how it's worked with your overall branding for the firm.
That was an intentional decision on my part. I wanted to, if I was going to grow a personal injury practice and a brand, I had to invest in marketing in myself. And, I think a lot of firms are uncomfortable with one partner in particular branding their own name and their own slogan. My partners were supportive of it, and I made that decision. I spent my own income on that. I didn't ask for money from my partners to support it, but I said, this is where I'm going with my practice. And they were on board because they didn't have to pay for it. I spent it out of my own income that I was generating. So it was intentional, and I'm happy I did it. I mean, I think it's really important to brand yourself long term.
100% agree. I've done it myself. As the founder of this company and an owner, I still invest in my personal brand because it gives opportunities for obviously business development, hosting a podcast, writing books. Those sorts of things are all things that ultimately can benefit the greater organization. I'm curious, with your practice, like how are you doing that without competing against your own colleagues? I mean, or is it you are still somewhat?
I'm not, because we're a multi-area practice, and so nobody's. I'm not stepping on my partner's toes. By doing what I'm doing with my marketing efforts. It's what I do with my marketing helps the branding of the firm, right? So, it drives more views, it drives more direct searches. It takes a lot of time, but, we are basically firms within a firm, right? So I'm kind of my own siloed budget. So are my, we have the workers' comp division. We've got criminal defense. We have probate estate planning, and I get internal referrals, and likewise they get referrals from me. So, for us it works. Doesn't work for everybody, but it's working for us.
Yeah, I think the key is when you've got practice areas like that are adjacent and complementary to some extent, or don't overlap as much, then that sort of a setup can actually work quite well. And I would think too, in your kind of market area, given the size and location of it, that probably helps as well.
Oh, for sure. It definitely does. My partner, Troy Wisehart, he probably, I know that he has the most branded, most searched name in Erie County for an attorney. He does criminal defense. He does it at a very high volume and has been incredibly successful in criminal defense. So his volume is huge. The amount of intakes that they get, frankly, is more than I get. And it helps one another. It's a good synergy.
Yeah, I'm sure. I'm curious, as someone who's built a very successful practice, where do you see the business of personal injury law heading over the next 3 to 5 years? Because there's so much changing right now with technology and, also now seeing some private equity entering into the equation with MSOs and the ABS models out of Arizona and some other jurisdictions where they're allowed. What do you think is the future, and how are you starting to prepare for what changes may be on the horizon?
There's a lot more national competition for the same cases that were, always there. I'm aware of that. That's why branding to me is very important. We've opened several remote offices. I guess I wouldn't even call them remote. We've opened other locations where we are adding local lawyers from that community. And, we're investing in them. We're investing in each of those markets with people that are actually part of the community, but under our brand. So I think branding is important. And we're just doing it location by location right now. And, delivering incredible customer service to the clients is huge, right? And how can you do better at that? Well, you need to be more efficient with your workflows. So, I have spent a lot of time and energy on our systems, our processes. I'm working with software engineers that are building custom workflows for us that are saving us tons and tons of time. And we're able to handle our cases more efficiently. And we're able to spend more time with our clients. So that has been my response to what, I think the future looks like in 3 to 5 years. And customer service, working with AI and software engineers to build processes that are going to make you more efficient, that are going to help your clients, and your personal branding. And those to me are the keys.
I'm curious about how you've gone about road mapping what can be taken on by technology that then allows the greater concentration on the customer experience and freeing up staff time. Because that's something that we're very passionate about as an outsourcing partner for law firms, because for law firms, the time they spend on what is an administrative task, lien resolution, takes away from their ability to, deal with another client, enhance the value of another case, get back in touch with a client, all those things that take time away from actually interacting with your client or increasing the value of that case. And the firms I've talked to about this that seem to have done it successfully have really created a roadmap for themselves of what processes are ripe for using technology to ultimately accelerate the practice and improve customer experience.
Yes.
How did you go about doing that?
I think the reality is now that anything that you can do on a computer or that you do on a computer, whatever process it is, which personal injury is process driven in a lot of ways, especially early on. Those processes can be automated. So you think about an intake call. Start with a transcript of the intake. Having that intake summarized and automatically uploaded into your case file and into your case management system. Automatically populating a fee agreement. Automatically populating a notice letter and preservation letters. And then those things are then reviewed by staff, right? So you use it as an assistant to help expedite whatever you're doing on the case. But the key is that whatever system you develop, it must require human review and human touch. And so the processes we're putting in place and we're building with software developers, at each step, they require verification and human review, where my staff is clicking, double checking. They're required to in order, before they even can take the next step. So that is what we've done, and we're starting to really put in place now. And that's where we're going to go. I mean, that's where we're headed. So, the key is that, getting the menial stuff done, and ready for human review and making everyone's life easier.
It's a great point about human in the loop, because the technology is incredible, but it has its limits. And at least right now, I guess we'll have to see where it all goes. But, the technology we built, we purposely wanted to have a human in the loop, because ultimately doing that validation, especially with people that have specialized expertise, like subrogation is an expertise and specialty. Technology can only do so much when it comes to that, but leveraging both, to me, is where the future lies for law firms, because there is something very unique and personal that ultimately people within the practice bring to that process that needs to be there still.
Yeah, for sure. So, big thing I would say about what we're putting in place, a key is having staff buy-in, right? Because some of these things are scary to the staff, right? Like they're worried that maybe they're going to be replaced. So I intentionally bring them into the process and help them understand what their role will look like, how it will change, how it will make their job better, more rewarding. They're going to be more efficient. And they actually get to have some feedback on what's going to work, because, we need to know what the staff are doing, and no one knows better than the staff themselves. So you have to bring them into the process. You can't just shop and listen to all these different vendors and say, we've got this amazing product that's going to change your practice. And then say, tell your staff, hey, here's what we're doing, right? That doesn't work. It does not. It falls flat. If you don't have buy-in and you don't have them involved in the process, it's not going to work. So I think that's really important to do for firms, because I've said, hey, we're going to use this product. We put it in place and we realize, well, it's not really working right for us. And had I had the staff involved earlier on in the process, I would have known that it wasn't going to work, right? So I've wasted money on different products that just didn't end up working for us. So that's kind of the lesson that I've learned.
Well, since we're talking about technology, I'm curious if you've seen the deployment of technology and the weaponization of it by the other side yet in, for example, trucking litigation cases, because, you're dealing with bigger corporate entities who maybe have a little deeper and vast resources. Are you seeing changes in the way the defense is approaching cases based on the use of technology?
I haven't seen it. I think some of my attorneys have noticed it through written email correspondence with adjusters. Their responses to some of our offers or their arguments are, I think, AI generated. They think is AI generated. So that's really right now the only place I've seen it. I think we're going to be seeing more and more of it for sure.
Yeah, I had a chiropractor on the podcast recently, and he was talking about some of these models that are being fed information, medical information, by insurers, and how that's being used to try and lower, diminish value of cases based on analysis of records. So I'm sure that more and more of that is going to occur. And
Sure.
At the end of the day, it's you guys are just going to have to continue to fight that use of technology with the facts, because oftentimes that's what combats that is, hey, the record is not accurate or doesn't have this or didn't take into account that, and all of those things that only humans can decipher and argue.
Yeah, I mean, we from my perspective, we've just embraced technology, and that's what we're going to continue to do.
Yeah, I don't think there's really any choice in the matter with where things are going. I don't see it getting less technologically advanced. Everything is moving at such a fast pace now that it's just going to get probably more and more complicated, but hopefully more and more tools to help trial lawyers continue to fight for people that need that help. And so you've been very generous with your time. So one more question, and it's a very open-ended question. I always ask it to wrap up the podcast, and you can answer it however you want. As a trial lawyer and someone who has built and scaled a very specialized practice, what is your view?
My view right now is that we need to be invested in trial and litigation. And we need to be invested in our brand and marketing, and we need to be invested in technology. Ultimately, trial lawyers are not going to be replaced by AI, right? So it's right now, I think, is critical as ever to distinguish yourself by trying cases, by working them hard in litigation, by doing as much training that you can, trying cases as a team. Trying a case solo is a heavy lift. But, I found trying cases with a team, a couple lawyers, a lawyer or two, reduces the load a little bit, and it's fun. I mean, it's fun. So we actually just are excited about it, about going to trial. We're excited about the workup. We're working cases more efficiently so we can work the cases up and spend more time, in litigation and getting it ready for trial. I am personally as excited as I've ever been about the future. I think we're, being invested in litigation and trial work is the future. And that's where we're headed.
Can you just briefly talk a little bit about your firm and your practice areas and the areas that you cover in case anyone listening has a case that they need to refer to you guys?
Sure, absolutely. So we all handle injury, personal injury cases, the general slew of cases, auto cases, premises cases. I do a lot of third party, like construction site injuries, because we have a workers' compensation practice. So a lot of times I'll have dual track case. It'll be a workers' comp case and then a third party lit case that I handle. So we handle workers' comp and the lit in-house. And we do trucking. dog bites, just all the normal stuff. What I don't do and we don't personally do in-house is medical malpractice. That's really about the only thing that we don't do from a litigation perspective. That may change, but right now it's really not our focus. And then we've got a general practice. We have criminal defense. We handle criminal defense cases across Northern Ohio and workers' comp statewide. Our injury practice is statewide. So, we're here to help with anything in Ohio.
And what's the best way to get in touch with you, Kyle?
I would say my email, kylew@ohattorneys.com. My personal cell phone, 419-366-7392. Or you can visit our website at www.ohattorneys.com.
Great. Thanks, Kyle. And appreciate you joining me on the podcast. And we'll see everyone on the next episode of Trial Lawyer Review.
Appreciate it. Thanks for having me, Jason. Take care.
If today's episode gave you a new perspective on how your firm operates or sparked a useful idea, consider sharing it with a colleague and be sure to follow the show so you don't miss future conversations with leaders across the personal injury space. Trial Lawyer Review is brought to you by Synergy, a strategic operations partner helping personal injury law firms resolve healthcare liens more efficiently. If you're looking to accelerate case flow and allow your team to focus on high-level legal work that moves cases faster, consider partnering with Synergy. I'm Jason Lazarus, and I'll see you in the next episode.